In this lecture, we shall continue with our discussion on judicial remedies. Judicial remedies. In our previous lecture, we discussed judicial remedies and we discussed private law remedies such as injunction, declaration, and an action for damages. We mentioned that even though injunction and declarations are ideally private law remedies, they have become increasingly important as public law remedies in contemporary times as well. So that in contemporary times, they may lie against public bodies as well. That is what declarations and then injunctions. And then also, we started looking at strictly public law remedies. And over there, we started with our discussion on certiorari, or a quashing order. For certiorari, we look at the definition of certiorari, it being a quashing order. We looked at the grounds under which certiorari may be granted, such as excess or lack of jurisdiction. We also looked at an illegal decision, that is a decision that is contrary to statutes. We looked at an error of law which is patent on the face of the record. We also looked at, in respect of administrative bodies, the Wensby unreasonableness. And then we look at in contemporary times when the Supreme Court can intervene in certiorari applications necessary to do, in instances when it is necessary for them to do justice. We look at the local standard for a person who can bring an application for certiorari, that it need not necessarily be a party to the suit, that it can be a person who is aggrieved by the decision. And remember, we look at a case in which a complainant in the criminal case was allowed to bring an application for certiorari. And then also, we went ahead to look at the fact that you need not exhaust the right of appeal before you can go for certiorari. And then finally, we look at instances whereby the court may exercise its discretion to refuse an application for certiorari if the applicant for the certiorari has already filed an appeal and is pursuing it. Now, we mentioned that having looked at certiorari, having looked at damages, having looked at declarations, having looked at injunctions, there's a need for us to look at the remaining public law remedies, which are habeas corpus, mandamus, and quo warranto. So in this lecture, we shall begin with our discussion on mandamus. Mandamus. Now, mandamus has been defined in the 8th edition of the Black's Law Dictionary as follows, and I quote: an action for mandamus is one brought in a court of competent jurisdiction to obtain an order of such courts commanding an inferior tribunal, a board, corporation, a person, or person to do or not to do an act, the performance or omission of which the law enjoins as a duty resulting from an office, trust, or station. Where discretion is left to the inferior tribunal or person, the mandamus can only compel it to act, but cannot control such discretion. End of quotes. Now, I had to bring this authoritative definition of mandamus as a preface to our discussion in this lecture, because it is important for us to remember at all times that mandamus is a strictly public law remedy. And therefore, it is only going to be directed against a public officer or a statutory body. Now, that public officer or a statutory body must have a duty which is imposed on that public officer or statutory body by the law. In other words, there must be a statute or there must be some law which is imposing a duty on that public officer to perform that particular duty. and then there must have been a demand of that public officer to perform the duty, and he may have refused to perform that public duty. In that instance, since the law has imposed a duty on him, the only way you can compel him to act is when you apply to the courts for a writ of mandamus to issue, because once the writ of mandamus issues, then it's going to lie from a court of competent jurisdiction. It is going to compel that public officer or the statutory body to do that specified act with the dictate of the law require that public body or statutory body to perform, especially when there has been a prior demand which has been led by a refusal to perform that particular duty. Now, it is important for you to note that once the writ of mandamus is granted and is issued, the effect of it is that it compels the performance of the public duty, which is owed to the applicant. Now, once that order is granted, you must go ahead and perform it. If the public officer fails to perform that specified function, then that public officer shall be liable for contempt of court. So now let us look at the grounds or the requirements that have to be satisfied before a person shall be entitled to bring an application for mandamus. The requirements that have to be satisfied before a person shall be entitled to the remedy of mandamus. Now, the first requirement that has to be satisfied is that mandamus lies against public institutions as a matter of right. You remember we said that these remedies are public law remedies and they don't apply in private law settings. So they're public law remedies. So they shall lie against public institutions as a matter of right. Second is that there must have been non-performance of the public or statutory duty, meaning that, first of all, you must be able to prove that it is against a statutory body or a public institution. Then there must have been a duty that they have failed to perform before you can bring that particular action. So if they have already performed that duty, then there's no basis for you to bring an application for mandamus. Also, it means that when there's no duty imposed on them by law, so that if it is just your personal request that you are making and there's no duty imposed upon them by law, then you cannot go and apply for another mandamus. So the second requirement is that it is only when there's a non-performance of the public or statutory duty, meaning that there must have been a duty. Then the third requirement is that there must have been a prior demand to the respondent by the applicant to perform that statutory duty. Note carefully, you, the applicant applying for the mandamus, you must have specifically made a prior demand to the respondent, and the respondent must have refused to perform that statutory duty. Now, finally, you, the applicant yourself, you must be a person who has the right, a specific legal right for the interference of the court. So you have a right for the duty to be performed, and then the duty has not been performed to you. So you have made a demand and they have refused, and so you are bringing an application for mandamus. And then finally, too, there must be no other equally convenient or appropriate remedy to apply for the order of mandamus. There must be no equally convenient or appropriate remedy. And remember that mandamus, it being a prerogative writ, is at the discretion of the courts. And if at the discretion of the court will look at the entire circumstances. And if the court sees that there is any other convenience remedy, which is more convenient, then the court may rather recommend you to go for that particular remedy. Now, I'll take each of these grounds one after the other and deal with them in extenso. But before I do that, let me just refer to the case of In re Butri and Mensah. In re Butri and Mensah. reported in 1959, Ghana Law Report at page 457. Now, this is what Olenuji said in the opening paragraph of his judgment. Now, I'm just reading this one for now, but I will come back to revisit this case again. In Botry and Mensah, 1959 Ghana Law Report at page 457. This is what Olenuji said. I'm just reading the opening paragraph, and I'll come back to it. Olenuji said, and as follows, and I quote, that among the conditions precedent for the issue of mandamus are the four set out in paragraph 7 of the statements of the applicants in support of the affidavits, namely, 1, there must be a legal right to be enforced, the purpose of which cannot be enforced by any other legal remedy equally convenient, beneficial, and appropriate. 2, there must have been a distinct demand and a refusal to act. 3, the duty to be performed must be some public or quasi-public legal duty. And 4, it must appear that the order would be effective. End of quote. So just bringing this over here, leaving this over here for now, to give you an idea of the grounds that must be proven before a person can apply for an order of mandamus. So the first requirement that has to be satisfied is that it lies against public institutions as a matter of right. It lies against public institutions as a matter of right. So on this issue, I refer you to the case of Mould and Divine. Mould is spelled M-O-U-L-D versus Divine, D-E-V-I-N-E. Mould and Divine. Now, the facts of this case are quite interesting. And so I'll reproduce the facts as captured in the headnotes so that you can understand why the application was brought for the order of mandamus. Now, these are the big facts as are captured in the headnotes. Now, Mr. Divine, former occupier of house number A162/3, Polygonal, Accra, had run up water bills to the tune of, and there's an amount of money. The Waterworks Department cut off water supplies to the house pending the payment of all arrears of water bills. On the 8th of November 1961, as a result of a court action, ownership in the house was vested in Agnes Mould, the applicant herein. The Waterworks Department refused to reconnect the water unless she paid the arrears. Now, this woman, Agnes Mould, who has become the new owner of the house, contended that the arrears were a debt due from the previous occupier, which the department could recover through a civil suit. So she was more or less directing the Waterworks Department that they should go and recover that money from a civil suit. But she is a new occupier and she's entitled to have the water reconnected. So because of that, she was arguing that she was entitled to have the house reconnected for water supply. She therefore applied for an order of mandamus to compel and order the Waterworks Department to restore the water supplies to the house. Now that you have an idea about the brief facts as captured in the headnotes, I shall now proceed to read the holding. Remember, we are talking about the case of Mould versus Divine. Mould is spelled M-O-U-L-D versus Divine, D-E-V-I-N-E. And we are talking about it in relation to the condition that mandamus would only lie against a public officer. Now, you know, in this case, the Waterworks Department will definitely be a public institution. So let's see what was held in the case. Remember, we are talking about Mould versus Divine. These are the holdings as captured in the headnotes. I'll read all four holdings from holding 1 to holding 4 as captured in the headnotes. And I read. Holding 1. Mandamus lies to compel a public body to perform a public duty which it has failed to discharge. Holding 2. The Waterworks Department has a duty to the public to supply water to their homes. It must show good cause why a particular house should not be connected. Holding 3. By Section 39 of the Waterworks Ordinance, Cap 67, 1951, the Waterworks Department is entitled to take civil action to recover debts due to it from landlords. The department cannot therefore use the fact of the divine's indebtedness as an excuse for refusing to connect water for the applicants. Then holding 4. An order of mandamus does not lie against the crown or the republic, but they can issue against officers of the state who have defaulted in performing a statutory duty. Now I had to go through all of these, that's the end of quotes. I had to go through all of these holdings just to establish one thing, that mandamus is going to lie against a public institution as a matter of right. Against a public institution as a matter of right. So the public institution in this case, you can see clearly, is the Waterworks Department. And what did the court say? That the mandamus would like to compel a public body to perform a public duty, which it has failed to discharge. And then they went on to say that the Waterworks Department has a duty to the public to supply water to their homes. It must therefore show good cause why a particular house should not be connected. The next requirement that has to be established is that there must have been a specific demand to perform that duty, which has been met by a refusal. That the person must have made a specific demand which has been met by a refusal. And on this, I refer you once again to the case of Butchery and Mensah, reported in 1959 Ghana Law Report at page 457. And this is what was held under holding 3 as captured in the headnotes. And I read that a condition precedent to mandamus is the applicant's prior demand to the respondent and the respondent's refusal. What the applicant did demand and what was refused was the charging of Butchery and Mensah. What they are now demanding was the reporting of their cases to a magistrate. This had not been demanded and had not been refused. And that's where the quote ends. And so we are told in this case of Butchery and Mensah, reported in 1959 Ghana Law Report at page 457, that it is a condition precedent to mandamus that the applicant must have made a prior demand to the respondents, which must have been met by the respondent's refusal. At least it has been made clearly over there. But the court just went ahead to give indications as to why this case even came about. Now, to put the holding in a better perspective, let me give you a brief background of the case. So the applicant in this case has actually made a complaint to the police that some people should be arrested. And in essence, yes, some people should be arrested. Now, after several back and forth, he got information that the people were eventually arrested, but the people were subsequently granted bail. Now, when the people were granted bail, he brought an action against the police. And this was the essence of the action that he brought. I'll quote in extenso what he was now asking the court to do when he applied for the mandamus. Remember, I'm saying that a complaint was made. After several back and forth, some people were arrested. The police took their statements. After that, the police released them on police bail. Now, this is what the applicant applied for, and I quote. So in the notice filed by the applicants, they applied for an order of mandamus against the Commissioner of Police and others for the following, and I quote, I quote now, to carry out his duties under Section 17 of the Criminal Procedure Code, to report the complaint made by Kwesi Botry and Kwesi Mensah against Kofi Akwa and others for extortion, fraud, etc. to a magistrate according to law, in terms of the relief sought in the statement accompanying the affidavit filed in support of the application. End of quote. Now, the specific relief that was sought by the applicant is as follows, and I quote once again. An order of Mandamus directed to the Commissioner, Ghana Police, Accra, to order him to perform his duty as required by Section 17 of the Criminal Procedure Code to report the complaint of extortion, fraud, and intimidation to the magistrate's court. End of quote. So you see, the applicants herein had made some complaints, people have been arrested, police have exercised their discretion to release the people on bail. Now you are bringing an application for Mandamus to compel the police that these very people that you made a report against, they should also be reported to the magistrates and be arraigned before courts. So now that I have that one, I'll read out in extenso the various holdings of the court so that you can understand why this case came about and how it relates to an order of Mandamus. So I'm reading from holdings 1 to 4 as captured in the head notes. And remember, we refer to this case to establish that there must have been a prior demand and a refusal. So let us listen to holdings 1 to 4 of the case of Inri Botry and Mensah reported in 1959 Ghana Law Report at page 457. This is what was held, and I quote, that there's no imperative duty upon the police officer to bring every person arrested without warrant before a magistrate court on a charge. That a duty is imposed. Yes, so that's holding 1. There's no imperative duty upon a police officer to bring every person arrested without a warrant before a magistrate court on a charge. Holding 2 is that a duty is imposed upon the police by Section 17 of the Criminal Procedure Code to report to the magistrate the cases of all persons arrested without warrants, whether admitted to bail or not. But this section exists for the protection of the liberty of the subject, but does not impose on the police a duty to charge all persons arrested without a warrant. Again, but this section exists for the protection of the liberty of the subject and does not impose on the police a duty to charge all persons arrested without a warrant. Holding 3 is that a condition precedent to Mandamus is the applicant's prior demand to the respondent and the respondent's refusal. What the applicant did demand and what was refused was the charging of Botry and Mensah. What they are now demanding was the reporting of their case to a magistrate. This had not been demanded and had not been refused. And holding 4, a further condition precedent to Mandamus is the existence of a legal right in the applicant. Section 17 of the Criminal Code confers upon the applicants, in this case, no legal rights to the charging by the police of the arrested persons. This case is so important that it gives you a lot of the requirements that have to be established before an order of Mandamus can be granted. It's the case of Inri Botry and Mensah, reported in 1959 Ghana Law Report at page 457. Let me take each of the holdings one after the other and then dwell on them. First one, I'll deal with the third one first and I'll come to the others. But a condition precedent to Mandamus is the applicant's prior demand to the respondents and the respondent's refusal. Remember we said already that there must have been a public duty, and that duty must have been imposed by the law. So whenever you apply for Mandamus, you must point to the law that has imposed the duty on that particular public officer or the statutory institution. In this case, the applicant are saying they have made a prior demand. But if you interrogate it, what was the demand they made? They made a demand that the people should be charged. Now, what were they demanding in the court now? They were demanding that the people should be reported to the magistrates. So the court held that what you are now asking from the court is not what you actually demanded. So we cannot grant you the order of mandamus, because for mandamus, there must have been a specific demand which has been specifically refused. And you have come to the court for an action to enforce that particular demand that you made. So if there's no specific demand which has been made by a specific refusal, please, you can't come for the mandamus. And that's why the court held in this case that what the applicant did demand and what was refused was the charging of butchery and mensa. What they now demanded was the reporting of their cases to a magistrate. That had not been demanded and had not been refused. So I brought this case to satisfy the second requirement of mandamus, that there must have been a prior demand that must have been met by a refusal. I believe in Mode and Divine too, when we read it, you realize that the person made a demand to the waterworks department and they refused. That is why the person brought an action against them for an order of mandamus. So we've seen two conditions so far for the mandamus. It must lie against a public body or a public institution or a statutory institution. And number two, there must have been a prior demand which have been met by a specific refusal. But let us look at the other holdings in this case of butchery and mensa to see how they can make our understanding of mandamus deeper. Now, holding one says that there's no imperative duty upon the police officer to bring every person arrested without warrant before a magistrate court on a charge. Why was this holding over there? Remember, we said that before you can bring an application for mandamus, there must have been a public duty. Now, this action that you brought to compel the police officer to bring the person arrested to report him before a magistrate, there's no duty like that that has been imposed on police officers. That was the first knockout we had, because they are not even met the first requirements that there must be a public duty imposed. The court is saying that there's no public duty even against the police officer that has to bring every person arrested before the courts. That's bring every person arrested to the court for the person to be charged. There's no duty like that. And then also the court noted that a further condition precedent to mandamus is the existence of a legal right in the applicant. You, the applicant here, what is the legal right you have here? The court said that the section 17 that we were referring to of the criminal code, it confers upon the applicant no legal right to the charging by the police of the arrested persons. It confers no legal right to the charging by the police of the arrested persons. And so because the applicant has failed to establish that condition precedent to the existence of a legal right, then they have failed to satisfy the condition precedent for the order of mandamus. So let us go back to the requirements for order of mandamus. We have mentioned first that it lies against public institutions as a matter of rights. And over here, we use the case of Mode and Divine. Mode and Divine. Then we said that number two, there must have been a prior demand by the respondent to the applicant to perform his public duty. And over here, we are referred to the case of butchery and mensa. Butchery and mensa, reported in the 1959 Ghana Law Report at page 457, where it was held in holding 3, that a condition precedent to mandamus is the applicant's prior demand to the respondents and the respondent's refusal. The third requirement is that there must have been a non-performance of the public or statutory duty. And I think this goes hand in hand with the case of Mode and Divine and butchery and mensa that we had looked at. Now, let me revisit the point about a prior demand that must have been met by a refusal. You remember in the case of butchery and mensa, we just noted that in holding 3, that a condition precedent to the mandamus is the applicant's prior demand to the respondents and the respondent's refusal. So the question is, what if you apply for an order of mandamus? What if you are made a demand to a public officer who knows the law, And because he knows the law, he didn't write any letter to you specifically refusing. But he was just there and didn't even mind you at all. 6 months, 7 months, 8 months, you've not heard anything from him. There's no refusal. Now, if you go according to unreasonable and Mensa, what it means is that you must be able to prove some letter or correspondence showing that they have refused. But in this case, you don't have any refusal from them. And you still go for the order of Mandamus. And you still go for an order of Mandamus. The answer to this case is provided in the case of Republic versus Court of Appeal, ex parte Lands Commission. Vanderpoy. Vanderpoy is what? Vanderpuye. Vanderpoy. And then Vanderpoy Orgil. Orgil is ORGLE. Estates Limited. Interested party. So Republic versus Court of Appeal, ex parte Lands Commission, Vanderpoy Orgil Estates Limited. Interested party. Reported in 1999-2000, One Ghana Law Report at page 75. We are trying to find out the answer on whether there must always be a refusal before you can apply for an order of Mandamus. And over here, I told you that the answer will be in this case, and I'm going to quote the dictum of Aqua JSE. And listen carefully to the dictum of Aqua JSE, because we will see our answer to that question in the dictum of Aqua JSE. Now, that's what Aqua JSE said, and I quote. And I'm quoting from page 128 of the report. And this is what Aqua JSE says. And I quote, "Indeed, the unreasonable delay by the Lands Commission in the way they dealt with the problem created by themselves makes it imperative to take legal action to compel them to sit up to their public duty. For a statutory duty must be performed without unreasonable delay. And if any such delay occurs, Mandamus may be employed to enforce the performance of such duty. Accordingly, in R versus Home Secretary, ex parte Fansopa, reported in 1976, Queen's Bench at page 606, Mandamus was granted on this ground against the Home Secretary when the Home Office insisted that a would-be immigrant who was legally entitled to enter England without let or hindrance should wait for over a year in the queue of applicants for entry certificates. See also the case of R versus Governor of Durham Prison, ex parte Singh. Singh is spelled S-I-N-G-H, reported in 1984, One All England Report at page 983. I'll take the quote once again. Indeed, the unreasonable delay by the Lands Commission in the way they dealt with the problem created by themselves makes it imperative to take legal action to compel them to sit up to their public duty. For a statutory duty must be performed without unreasonable delay. And even if such delay occurs, Mandamus may be employed to enforce the performance of such duty. End of quote. And why am I reading this case? I'm reading this case because we have been told already in the case of Inri and Mensa that before you can bring an application for Mandamus, it must lie against a public body or a public institution, and that there must have been a specific demand which has been met by a specific refusal. And I'm asking whether it is in all cases that you must prove this specific refusal. Now, in this case of ex parte Lands Commission, Vanderpoy Orgil Estates Limited interested party is telling us that it is not in all cases that you must be able to prove this particular refusal. Aqua JS is saying that if there has been an unreasonable delay then you can bring an action against them to compel them to perform their statutory duty. And APA-GS even referred to the English case where an immigrant that had the right to enter England had applied to enter, and they told the immigrant to wait for 1 whole year in the queue of the applicant for entry certificates. That was an unreasonable delay. And so the person could apply for an order of mandamus. And so all I'm saying over here is that even though we have been told in More and Divine, and we've been told in Remedies and Mensa that there must have been a specific demand that must have been met by a specific refusal, take note that it is not in all cases that the court will require a specific refusal. And that if there has been an unreasonable delay, the court may be entitled to still grant you the remedy of mandamus. So let's go back to our requirements for mandamus. We look at 3 requirements so far. The first, it lies against public institutions as a matter of rights. Secondly, there must have been and over there we look at the case of More and Divine. Number 2, that there must have been a prior demand to the respondent and by the applicant, and the respondent has failed to perform that particular public duty. And over there we look at the case of Remedies and Mensa. And now we have looked at the case of Republic versus Court of Appeal, ex parte Lands Commission, Vanderpoel Estate Limited, interested party, which is reported in 1999-2000, One Ghana Law Report at page 75, where APA-GS said that it is not in all cases where there must be a refusal, and there is a delay, you may be entitled to bring an application for mandamus. So that brings us to our third element, that there must have a non-performance of that public or statutory duty, meaning that if the duty has been performed, then there will be no need for you to bring an application for mandamus. Now, one over here too is a very interesting requirement, that there must have been no equally convenient or appropriate remedy. There must have been no equally convenient or appropriate remedy. What does this mean? What this means is that if you are bringing an application for mandamus, remember that mandamus is a discretionary remedy. So if we can show that by this application for mandamus report, there's another remedy in the law, there's another procedure in the law that can give you a more expeditious remedy, but you rather come and brought the application for mandamus. If you come this way, then the court may hold that at the end of the day, then there's no need for you to even come for the mandamus. You should be entitled to the mandamus only when you can show that this is the most beneficial and appropriate means for which you are bringing the action to maintain that, to get that particular remedy. But if there's an alternative remedy which can expeditiously grant you your remedy, then the court is supposed to exercise its discretion and they refuse your application for the mandamus. And on this, I refer you to the case of Republic versus Court of Appeal, ex parte Lands Commission, Vanderpoel Estate Limited, interested party, reported in 1999-2000, One Ghana Law Reports. And on this, I refer you to look at the holding 3 as captured in the head notes. And this is what it says, and then I quote. Although generally the existence of an alternative remedy against a refusal to carry out a public duty had been regarded as an impediment to an application for an order of mandamus, the courts exercised a wide discretion in determining whether a statutory alternative remedy was to be construed as a bar to an application for mandamus. The major consideration was whether on the facts and in particular the issue raised for determination, mandamus would be more convenient, beneficial, and effectual than the statutory remedy. I'll take that again. The major consideration was whether on the facts and in particular the issue raised for determination, mandamus would be more convenient, beneficial, and effectual than the statutory remedy. Charles Hayfrom Benjamin noted as follows, and I quote, that even where there was an alternative process it was not an inflexible rule that the statutory procedure so laid down had to be followed. In the instant case, since the appellant did not comply with the provisions of Acts 123 by furnishing the respondents with a written refusal, which was a condition precedent for an appeal under Acts 123, the respondents could not have invoked the appeal process under Acts 123. The High Court therefore rightly exercised its discretion in granting the mandamus against the appellants. End of quote. Now, what are we saying over here so far? All we are saying is that one, there's a general rule that when there's an alternative mechanism in law that you can use to be entitled to the remedy of mandamus, then the court will rather require you to go and use that alternative procedure and not come for the mandamus. But that is only if that other mode is going to be more convenient, more beneficial, and a more effective remedy. And so in this case, the court noted that at the end of the day, this mandamus the person has got is the one that is more beneficial, more effective, and the more convenient for the person to get his remedy. Because the other mode that you're even telling him to go for, what the Lands Commission had to do for him to even appeal under that act, they have not even given him the refusal for him to even appeal under that act. So how do you decide that he should rather go and exercise his right of appeal under the Act 123? So rather, what will he do? He will rather come under mandamus, because that is the more effectual, that is the more convenient, that is the more beneficial remedy that he can be entitled to if he brings the application for mandamus. So please, take note of what Charles here from Benjamin said, that it is not an inflexible rule that anytime there's another alternative procedure, then you must go for that alternative procedure and you can't come for mandamus. The courts always have to look at which one was more beneficial, which one was more convenient, which one was more of an effectual procedure and remedy that will be convenient to the applicants. So we are going back to our requirements for order of mandamus. One, they are saying it must lie against public institutions as a matter of rights. And over there, remember the case of Mood and Divine. We said that there must have been a proud demand to the respondents, which have been met by a refusal. And over there, remember the case of Unreasonable and Mensa. And we have said that it must lie only when there's a non-performance of the public or statutory duty. And over there, you can still use the case of Unreasonable and Mensa, and you can use the case of Mood and Divine. Mood and Divine was when the waterworks refused to connect the water for the applicants. Unreasonable and Mensa was about compelling the police to charge and bring the person before the magistrates. So 3 requirements so far: that it lies against public institutions, and we see the case of Mood and Divine. There must have been a proud demand to the respondents, which have been met by a refusal, and over there you look at the case of Unreasonable and Mensa. But remember that it is not in all cases that there must have been a proud demand and the refusal. There are times when an unreasonable delay would entitle you to bring an application for mandamus. And over there, you can look at the case of Republic versus Court of Appeal, as per the Lands Commission, Vanderpoel Ogill Estates Limited, interested party, that if there's an unreasonable delay, it may still entitle you to bring an application for mandamus. And then also, we have looked at the requirement that there must have been a non-performance of a public or statutory duty, which is our 3rd requirement. And then fourthly, we said that there must have been no equally convenient or appropriate remedy. And that's what you are seeing again in this same case of Republic versus Court of Appeal, as per the Lands Commission, Vanderpoel Ogill Estates Limited, interested party, where the court held that if there is a more convenient, more effectual remedy, then that's when the court will rather allow you to go for that more convenient remedy. And you saw in this, as per the Lands Commission case, where the court held that mandamus in this case was the more effectual remedy to apply for the remedy of mandamus. And the 5th requirement that I may just add is what we saw in the case of Unreasonable and Mensa, that the applicant for an order of mandamus must demonstrate the existence of a legal right to have the order granted. So the applicant must demonstrate the existence of a legal right to have the order of mandamus granted. The applicant must demonstrate the existence of a legal right to have the order of mandamus granted. So, summarize all the five now. One, there must have been a public duty. So, first of all, it lies against public institutions as a matter of rights. Number two, there must have been a prior demand that are met by a refusal. Number three, there must have been non-performance of that public duty. Number four, there must be no equally convenient or appropriate remedy. And number five, there must be the existence of a legal right in the applicant. Now, I believe by now, you have several authorities to justify the requirements that have to be satisfied for an order of mandamus to be granted. Except that when you look at the case of irrebuttary alone, and even the ex parte lands commission, you can get all your requirements over there. But I want to solidify and cement your law on mandamus. And so I'll read out two Supreme Court decisions in Ghana, one in 2010 and one in 2018. And that is what we need to finally cement the position of the law on mandamus in Ghana as it stands now. And so the first case I'll read is the one in 2010, and it's a case of Republic number 2 versus the National House of Chiefs, ex parte Akwafaku Koko II, and Nemil the 5th, interested party number 2. This is reported in 2010 Supreme Court of Ghana Law Reports at page 134. And I'll read the concurring opinion of Doche GSE, and I quote, "The law has been fairly well settled that in order to ground a successful application for mandamus, there must be a demand and a refusal. This issue was addressed by Anan J, as he then was in the case of the Republic versus Chieftaincy Secretariat, ex parte Adanse Traditional Council, reported in 1968 Ghana Law Reports at page 736, where an apt summary of the law and the grounds upon which a party may seek the redress for mandamus were stated by the court. The court stated thus, and I quote, "An order of mandamus would like to compel performance of the duty at the instance of a person aggrieved by the refusal to perform that duty, unless another remedy was indicated by the statutes. But before a court will make such an order of mandamus, the applicants must satisfy 4 conditions, namely, A, that there was a duty imposed by statutes upon which he relied. B, that the duty was of a public nature. C, that there had been a demand. And D, there must have been a refusal to perform that public duty enjoined by statutes." Clearly then, the appellant, in my estimation, has more than satisfied this demand and refusal criteria to maintain an application for mandamus. See also the decision of Apatu Plans J, as he then was in the case of Republic versus Nana Ekroma Boateng II, ex parte Dansoa and another, reported in 1981 Ghana Law Reports at page 333, where the court inter alia held as follows, and I quote once again, "Before the court would issue a mandamus, there must be evidence of a demand to perform the act sought to be enforced, and that the demand was met with a refusal." End of quote. And now I'm proceeding to read a dictum in ex parte Akwafaku Koko. So the court went ahead. That is, the basic principle is borne in mind, and an applicant right has accrued several years ago and has been demanding performance of that duty and only recently had a response. Time would begin to run from the date of the response. Even then, the type of response received will determine whether time should begin to run immediately or from a reasonable time thereafter. If the learned justices of the Court of Appeal had critically considered this demand and refusal criteria and how it was an issue in the case before them, they would have come to a different conclusion. In the case of the Republic versus Lands Commission, ex parte Vanderpoel Ogill Estate Limited, reported in 1998-99 Supreme Court of Ghana Law Report at page 677, where the majority of the courts, per Manford Ado, Charles Hayford Benjamin, Aqua, and Sophia G. Justice of the Supreme Court, Ampere GSC dissenting, held entirely as follows. And I quote once again: the unreasonable delay by the Lands Commission in the way they dealt with the problem created by themselves make it imperative to take legal action to compel them to sit up to their public duty. For a statutory duty must be performed without unreasonable delay, and that if any such delay occurs, Mandamus may be employed to enforce the performance of such duty. End of quote. And I'm proceeding to still read from ex parte Akofa Kukoko. The court went ahead. It is therefore clear that the court will recognize the existence of duty and its performance by a public body as a criteria for the grant of mandamus. Indeed, the learned authors of De Smith, Wolf, and Joel, treating the subject in their usual detail in their book, Judicial Review of Administrative Action, 5th edition, page 700, paragraph 16 to 012, writes on mandamus as follows, and I quote again: demand and refusal, it is preferable for the applicant to be able to show that he has demanded performance of the duty and that performance has been refused by the authority obliged to discharge it. An applicant, before applying for judicial review, should address a distinct and specific demand or request to the respondent that he perform the duty imposed on him. End of quote. As part of we proceed. The court noted that cases which support the above formulation are the State Modern Homes Ireland Limited versus Dublin Corporation, and also Republic R versus Board of Commissioners of Public Utilities, as part of the Halifax Transit Corporation. And now, my concluding aspect from this case of ex parte Akofa Kukoko, the court noted as follows, and I quote: however, where the demand made for the performance of the duty has been found to be premature, mandamus will not lie. See the case of R versus Bristol and Exeter Railway, reported in 1843, 4 Queen's Bench at page 162, and R versus New Westminster City, as part of Canadian Wire Vision Limited, reported in 1965, 48 DLR, which established the principle that whenever the demand was not made in the prescribed form, the application will be refused, and was indeed refused in the New Westminster case. The case of R versus Secretary of State for the Home Department, ex parte Fansopa is spelled PHANSOPKAR, Fansopa, reported in 1976, Queen's Bench at page 606. However, states that the mere fact of non-compliance with the duty is sufficient for the award of a mandamus, where the applicant has been substantially prejudiced by the respondent's procrastination. Again, emphasis. Where the applicant has been substantially prejudiced by the respondent's procrastination, that the mere fact of non-compliance with the duty is sufficient ground for the award of a mandamus, where the applicant has been substantially prejudiced by the respondent's procrastination. End of quote. And so, what do we get from this case so far? What we get from this case so far is that even if there has been no refusal, but there has been an undue delay which has prejudiced the position of the applicants, then the courts will be entitled to grant the remedy of mandamus. And then finally, let me wrap up with the discussion on mandamus with the case of Republic versus the Registrar and President of National House of Chiefs, Kumasi, and also the Registrar and President of the Central Regional House of Chiefs, Cape Coast, ex parte ebusuapanyin Kojo Yamwa and Nana Aboy Yamwa. And this is what Apple JSC had to say, and I quote: "We agree that as a general rule, Mandamus would not be granted unless the party complained of and had what if he was required to do, so that he had the means of considering whether or not he should comply. And it must be shown by evidence that there was a distinct demand of which the party seeking the mandamus desired to enforce, and that demand was met by refusal. It has been held that the demand and refusal principle is not applicable in possible cases. For instance, it would not apply where a person by inadvertence omitted to do or perform an act he was under a legal duty to do, and whence and where the time within which he could do it had expired or passed. See the case of Republic number 2 versus National House of Chiefs ex parte Kofa Kukoko II, and Nemo the 6th interested party number 2, reported in 2010 Supreme Court of Ghana Law Report at page 134. Again, Mandamus would not lie where the demand is premature. However, the mere fact of non-compliance with a duty would be sufficient ground for the award of Mandamus, where the applicant had been substantially prejudiced by the respondent's procrastination. As Rice J. opined in the case of R versus the Guardians of Lewisham Union, reported in 1879, 1 Queen's Bench, page 498 at 500, an applicant in a mandamus application must first of all show that he has a legal right to ask for the interference of the court. Again, this same position was expressed in Housbury's Laws of England, 3rd edition, volume 11, at page 84 as follows: "The purpose of mandamus is to supply defects of justice, and accordingly, it would issue to the end that justice may be done in all cases where there is a specific legal right and no specific legal remedy for enforcing that right. And it may issue in cases where, although there's an alternative legal remedy, yet that mode of redress is less convenient, beneficial, and effectual." End of quote. This is the case of Republic versus the Registrar and President of the National House of Chiefs, Kumasi, and another ex parte, Ebusuapanyin Kojo Yamwa, and another. And they are also affirming all the pointers that we saw in ex parte Akufa Kukoko, that one, there must have been a prior demand, there must have been a refusal. It's not in every case that there must be a refusal. There are times when the undue delay will entitle you to bring an application for mandamus. And take note of what they quoted from the Housbury Laws of England, that even though there may be an alternative remedy, you can still come for mandamus if mandamus will be the more effective, beneficial, and convenient remedy that you can get. So, by way of summary, what we have done so far is that we have discussed mandamus, we have discussed the grounds under which the court may grant the remedy of mandamus. We have also looked at the requirement that has to be established before the court will grant a remedy of mandamus. And for the requirements, we looked at one, that it will lie against public institutions, that there must have been a prior demand to the respondents to perform that duty, that there must have been a non-performance of that public duty, and that there's no other equally convenient mode or mechanism for getting the remedy, and that you, the applicant yourself, you have a legal rights to be entitled to the remedy. And remember, and not in every case that there must have been a refusal. You may be entitled to go for the mandamus if there has been an undue delay which has prejudiced the position of the applicants. This is where we shall draw the curtains on our discussion on judicial remedies, specifically mandamus. Thank you.